Today, in my lecture, I will discuss divorce under Muslim law and its various dimensions, aspects connected with the main topic. uh, I have already pointed out, and at the cost of the repetition, nikah or Muslim marriage, according to the established authorities, is a solemn pact or covenant between the two persons of consenting age of the opposite gender or opposite sexes. It is an exclusive union of the two persons which is based on the mutual consent, or that is offer by one and acceptance of the same by the other party to the union. I have also pointed out in my previous lecture that it is a union of love, affection, mutual respect, loyalty, and obedience. After the formal solemnization of the nikah or Muslim marriage, it takes a form of the legal contract, and being a contract, it affords option to the spouses to repudiate it. Since the marriage plays a significant role in the community life as well as in the life of the individual, therefore Muslim law teaches great respect for it and has encouraged the spouses as well as the people to keep the union alive even in the most turbulent situation until the death of either of them. This fact is also evident from the verses of the Holy Quran, which is the fundamental source of Muslim law. But due to paucity of the time, I may not directly quote the relevant verses. But it is the teaching of the Holy Quran itself that parties to the marriage are required by the divine law to maintain the union of marriage as far as possible, uh, even if one spouse finds some defect in other and vice versa. However, if spouses are not pulling on well, because it is a union of the two persons who have agreed to live together as a husband and wife for the lifelong, and they are also supposed to fulfill all the mutual spousal rights and obligations arising out of the contract of the marriage. However, since it is a bilateral union, it is an agreement of the mind. It is a sort of the contract between the two persons who have agreed to live together uh, for lifelong until there is a dissolution of the union due to the death of either husband or wife. But it may not be ruled out from the human nature that when two persons are living together under an agreement, friction in the relation is bound to happen. And due to the frictions, parties may start losing the confidence, faith in each other. As a result, they may not be pulling on well for attending facts and circumstances or for the reasons which may be beyond their control, and consequently they might have lost the mutual trust, affection, fidelity, which are core object of union of marriage. Therefore, if this situation has emerged during the continuance of the marriage between the parties that they are not pulling on well, for the reasons known to the parties, and since they are not pulling on well and therefore friction has come in their relation, and due to the frictions they have lost confidence in each other, they have lost the trust in each other, and they have lost the mutual love and affection for each other, fidelity for each other. Then in this situation the union becomes just like an empty shell and useless. Therefore they can separate from each other in this situation by dissolving their union which was constituted by means of marriage. This shows very clearly that divorce is very last remedy which can be resorted to in the extreme situation that is contemplated by the fundamental sources of the Muslim law, and they are that when the spouses are contemplating a reasonable apprehension of breaking the limits set by divine law. If the spouses find it impossible to live together due to the mutual friction which is necessary for fulfilling the mutual obligations, they are given legal means, that is the divorce, to separate from each other for their own good, for the goodness of the family, as well as the society at large. Therefore, it may be clarified that Muslim law prefers union of the marriage and continuation of the union of the marriage until the death of either the spouse. However, since it is a union of the two persons, therefore frictions in relation are bound to take place. If due to the mutual frictions parties are not pulling on well, they have lost the confidence in each other, divorce is allowed or permitted only in this situation. This is the situation which is contemplated by the fundamental sources of the Muslim law, permitting separation from each other, that too by a legal means, and the means which is provided or which is accorded by the fundamental sources of the Islamic law to the spouses to separate from each other by breaking the marriage on the grounds which has made their living beyond the possibility together. Only in that situation they are allowed to separate from each other by breaking their relationship established by means of the marriage, and that very legal means sanctioned by the divine law to the spouses or parties to the marriage to dissolve it due to the attending facts and circumstances. That very legal means is known as divorce, which is sanctioned, which is allowed for the good of the parties, for the welfare of the family, in the larger interests of the society. And this legal means is known as divorce. Basically, nikah is a legal means whereby two persons unite with each other in marriage, whereas the divorce is a legal means. It is an instrument, it is a method, it is a process in the exercise of which union of marriage is dissolved, repudiated, or finally terminated. So basically, divorce is a procedure, process, it is a method, it is a means by which the union of marriage is repudiated either by the husband, or it can be repudiated under certain circumstances even by the other spouse, that is, by the wife. Therefore, the literal meaning of the word talaq is to snap off or to separate. And when this word talaq is translated into the language of law, it means the freedom from the bondage or from a contract. In this way, the divorce in Sharia law means and implies terminating with explicit or implied words the bond created by the marriage contract. So, in a very simple language, divorce put to end all the valid relations created, generated by another process that is known as nikah or marriage. There is lot of the misgiving about the topic of the divorce, and therefore this topic of Muslim law is said to be the most controversial part of the Muslim law. And one of the misgiving regarding the topic of the divorce has been, right from the day first, whether the right to divorce is exclusive right of one party, that is of the husband, or under certain circumstances, on certain conditions, by certain means, it can also be repudiated, it can also be terminated, or can be put to end by the other spouse who happens to be female biologically. Here I would like to clarify that the divorce or right to divorce or privilege of divorce for repudiating the marriage under Muslim law is not only the right of the husband, but this facility, rather it is not right or it is not privilege, rather it is a kind of the, it is a type of the facility which is available to parties to a marriage to redress a grim and exceptional circumstances which has which is in and around the life of the married partners. Therefore, Muslim law, this facility under Muslim law, the facility of divorce is not only the right of the husband, is not only the right of one party to the marriage, but the other spouse of a Muslim marriage who is called wife, and by nature she is female, this right is available to her also, and like the husband, she can also repudiate the marriage under certain circumstances, on certain conditions, by adopting a process or procedure or rule sanctioned by Muslim law. When the dissolution of Muslim marriage proceeds from the husband, it is called as talaq, meaning thereby that when the union of the marriage is terminated or repudiated by pronouncing or by uttering some words that is known as talaq under Muslim law. However, as husband can repudiate the marriage by pronouncing the talaq upon his wife, In the same way, a Muslim wife may also seek the dissolution of her marriage by uh, means of khula, that is a process, a method approved by the Sharia, Mubara, another method sanctioned by the Sharia law. Then there is another method whereby a Muslim wife is allowed to terminate the marriage by even uttering the words like husband upon herself to terminate the marriage, and that very method or procedure or formula is known as Talaq Tafweez, that is also called as delegated divorce. Therefore, it must be crystal clear to the audience at large that under Muslim law, in matrimonial alliance, both the spouses stands on equal footing with equal rights and privileges. In case of the marriage, for in order to constitute a valid union of the marriage, consent of the both the parties is fundamental requirement. If there is no consent of the either spouse, union will not be a valid union. In the same way, in case of the exceptional hardship and necessity, if divorce has become at all inevitable, parties are not pulling on well, their relation has poisoned to such an extent that they have gone to the point of no return. They have started disliking each other, have lost the mutual fidelity. In that very situation, law allows the separation. However, separation can proceed from the husband, it can proceed from the side of the wife. Proposal for separation can proceed from the husband. Proposal for separation can proceed from the wife sometime. Sometime under certain circumstances, even proposal for dissolution of marriage or divorce can be with the mutual consent of the parties, that is of the spouses of a marriage. And therefore, not only in the matter of marriage, but even in the matter of the dissolution of marriage, both the parties by the divine law have been treated on equal footing, as they have equal rights, equal privileges, and equal duties for each other. Therefore, allegation that under Muslim law, right to dissolution is the exclusive right of the husband and wife is deprived of it, is totally misplaced, misconceived. It is not true. A plain reading of the fundamental sources reveal abundantly that dissolution, right to the dissolution is a bilateral right available in the given circumstance on a valid ground to both the spouses, that may be husband or that may be a wife, as the case may be. I would like to discuss different modes of the divorce by putting up how the divorce has been classified, or what is the classification of divorce. Muslim law recognizes following modes of the dissolution of marriage. Means that how the marriage can be repudiated. Modes means a method. What are the formulas, different formulas uh, in the exercise of which a union of marriage can be dissolved. So the different formulas made available to the parties are available to the parties under Muslim personal law for the dissolution of marriage or for effecting the dissolution of the marriage basically is called as classification of a divorce or classification of the divorce. So divorce has been classified into following classes, that is divorce by husband, which includes talaq, ila, zihar. So these are the different formulas. By invoking either of them, a Muslim husband can repudiate his marriage. Likewise, the other formula is known as divorce by wife. Means there are certain formulas which are within the power of a Muslim wife. By invoking either of them, she herself can repudiate the union of her marriage, and the formulas effecting the divorce at the end of the wife, they are known as talaq-e-tafweez. The other class of the divorce is divorce by mutual consent. Means sometime under certain circumstances, marriage can be put to end by mutual consent of the parties, and the formula which can be resorted to for divorce by mutual consent, those formulas are known as khula in legal terminology, mubarat or mubara. The other class of divorce is known as divorce by judicial decision. This includes 9 special grounds available to the wife under the dissolution of Muslim Marriage Act 1939, and they are whereabouts. If the whereabout of the husband has not been known for a period of 4 years, or that the husband has been neglected or has failed to provide her maintenance for a period of 2 years, the husband has been sentenced to imprisonment for a period of 7 years, husband has failed to perform. In this way, there are 9 grounds. On the existence of either of them, a Muslim wife can file a suit before a court of competent jurisdiction, and on the proof of either of the ground as mentioned under section 9 subclass 1 of the Dissolution of Muslim Marriage Act 1939, if the court is otherwise satisfied with the averment of the petitioner wife, the court can pass a decree of divorce dissolving the marriage, and decree or order passed by the court of competent jurisdiction in effect will be as good as the divorce personally pronounced by the husband upon his wife in order to effect the dissolution of marriage.